Look at what happened in court today. The okay. We look at the Michael Bryan murder trial and the murder of Ahmaud Arbery. Once again, it's not the Ahmaud Arbery trial. It's when you look at the case, it's Georgia versus McMichael, Georgia versus Bryan. It's Gregory McMichael, Travis McMichael, and William Bryan who were on trial. So the prosecution did their rebuttal closing argument today, and the jury is deliberating. Let me see here. And the jury is deliberating. So if we look at the updates from the New York Times, the judge sent the jury home after the first day of deliberations. The jury will resume discussing on Wednesday. They're coming back at 8:30 a.m. They wanted to work later today. It appears that they're close to a verdict. We'll have to see. Some people are estimating that because Thanksgiving holiday is coming up, they want to go ahead and get a verdict before Thanksgiving. Now, if they don't come out with a verdict on Wednesday, they'll have Thanksgiving Day off and they'll come back to deliberations on Friday. But the case is pretty clear. The evidence is overwhelming against the defendants. Let's see here. There's one part I wanted to go to. Okay, let me go to this clip. I want to find the section I wanted to find here. Let's go to NBC Nightly News about what happened today in court.
For the family and friends of Ahmaud Arbery, after months of agony, the jury in this case now deliberating.
I do think that we will come back with a guilty verdict. We will get justice for Ahmaud.
At points during the prosecution's rebuttal, graphic photographs of the crime scene causing Ahmaud Arbery's mom to cover her face. 3 men in this case face 9 charges, including aggravated assault and murder with malice aforethought, which can be formed in an instant.
It has nothing to do with anger or hatred for a person. Instead, it deals exclusively with the concept of intent. Intent to kill, intent to cause serious bodily harm.
The prosecutor telling the jury a self-defense claim cannot apply when you create the danger and confront an unarmed victim.
This isn't the Wild West. He moved toward Mr. Arbery with the gun.
A message they hope sticks with the jury.
What's potentially the power of these last 2 hours being the final thing the jury will hear before they start deliberating?
She has a fresh jury. The jury has had all the evidence, and so it's great that right before they go into deliberation, they'll be hearing from the prosecution, making their case, and hopefully getting a conviction.
Throughout the trial, the defense staking its case on a series of neighborhood burglaries. They say the 3 defendants were trying to peacefully confront a man they believed was at least trespassing.
These are real experiences, real people who were very scared. And so they took it upon themselves to do something about it.
Now, the fates of 3 men and the families devastated by their actions hanging in the balance.
So, Sam, what's the plan for this jury now? Will they be deliberating throughout the Thanksgiving week?
Lester, originally it was thought the jurors might recess early for the holiday, but now the sheriff's department says they have the option to deliberate throughout the week, the holiday, Friday, maybe even Saturday. They almost went late tonight, Lester. We'll be back at 8:30 in the morning.
Okay, so that is from NBC Nightly News, Tuesday, November 23rd. You can check that out at NBC.com. All right. if we look, I want to look quickly here at this article, then we're out of here. Okay, jury to resume deliberating on Wednesday. The piece I want to look at is the jury will now weigh multiple interlocking charges in the Arbery murder trial. It's not the Arbery murder, just the murder trial in the killing of Ahmaud Arbery. It's the Michael Bryan murder trial. So we look at this here from New York Times and their updates. The task before the jury in Brunswick, Georgia, is not just a matter. It's not just a matter deciding between guilty or not guilty on a particular charge. The jurors must sort through a matrix of interlocking charges in different forms of culpability or responsibility that can depend on one another, in different forms of culpability or responsibility that depend upon one another. Here are some of the complications. Could they all be guilty of what any of them did? Could they all be guilty of what any of them did? Now, the indictment charges the three defendants, Gregory McMichael, Travis McMichael, William Bryan, both individually and as, quote, parties concerned in the commission of a crime. Parties concerned in the commission of a crime. Now, under the law, if the jury finds that one of the men committed a felony, it can convict them all of that crime. Okay, under Georgia state law, if the jury finds that one of the men committed a felony, it can convict them all of that crime on the basis that they were acting together. This issue is especially important for William Bryan, whose lawyer, Kevin Goff, has tried to distance him from the other two defendants, arguing that William Bryan was just a witness to events and had no hand in actually harming Ahmaud Arbery. Does it matter what the men set out to do? Does it matter what the men set out to do? Now, to convict on the top charge, malice murder, the jury would have to find that the men had a deliberate intention to kill. Okay, the jury would have to find that the men had a deliberate intention to kill without considerable provocation. But the other murder charges in the indictment do not depend on whether the three men meant to kill Ahmaud Arbery. Defense lawyers have argued that the men were attempting to make a citizen's arrest, even though they did not tell Ahmaud Arbery they were trying to make a citizen's arrest, and even though they didn't tell the police who arrived on the scene that they were trying to effectuate the citizen's arrest. They ain't say that then. The prosecution has argued they had no justification for a citizen's arrest and could not claim self-defense because they instigated the confrontation and they chased Ahmaud Arbery for 5 minutes. Now, the lesser charges create 4 paths to felony murder. The lesser charges create 4 paths to felony murder. The men are accused each of 4 other serious felonies besides murder. But each of those charges also lead to a murder conviction. Okay, the men are each accused of 4 other serious felonies besides murder. But each of those charges could also lead to a murder conviction. Now, under Georgia state law, and all this deals with law, politics is the legal distribution of scarce wealth, power, and resources, and the writing of laws, statutes, ordinances, amendments, and treaties, their adoption, interpretation, and enforcement. And you have law enforcement, and you have the courts, and courts interpret law. Under Georgia state law, causing a person's death in the course of committing another felony is murder. Quote, irrespective of malice, end quote. In other words, regardless of whether the death was intentional or accidental. Under Georgia state law, causing a person's death in the course of committing another felony is murder. Okay, regardless of malice, regardless of whether the death was intentional or accidental. Different states, murder is the elements that are needed to get a conviction on murder vary from state to state. You're dealing with state law, and the 10th Amendment to the U.S. Constitution gives states rights so they can have variations in these various laws. So if the jurors find the men guilty of any of these crimes, aggravated assault with a deadly weapon, the shotgun, Travis Michael shotgun, aggravated assault with something likely to cause serious bodily harm, pickup trucks, false imprisonment, the citizen's arrest, or attempted false imprisonment, and then find Ahmaud Arbery's death was caused along the way, they could convict the men of felony murder as well, without having to find that they intended or tried to kill him. So the jury has to deliberate over these interlocking charges. One count against William Bryan, the jury can consider reduced on one count against William Bryan, the jury can consider reduced charges. The judge said in his instructions to the jury, Judge Walmsley, that on one count in the indictment, aggravated assault involving the pickup trucks, they could consider whether one of the defendants, William Bryan, was instead guilty of a reduced charge of simple assault, reckless conduct, or reckless driving. They could consider whether William Bryan was instead guilty of a reduced charge of simple assault, reckless conduct, or reckless driving. Those are misdemeanors in Georgia, not felonies, so a conviction on one of the reduced charges would not expose William Bryan to a felony murder charge in connection with that count. So this is what the jury has to determine. Okay, exactly what are they guilty of? Which charges are they guilty of? And they're interlocking charges. Okay, so read the updates from the New York Times, and read this piece here from the New York Times. The jury will now weigh multiple interlocking charges in the Michael Bryan murder trial and the murder of Ahmaud Arbery. All right. So, okay, so we got that, and lastly here, let's see, let's squeeze in this clip. This is my girl Candace Kelly. We were co-panelists on Roland Martin Unfiltered last Friday, and she does legal analysis for the Black News Channel, and she was on Start Your Day with Sherry. She was on today talking about the case. She was on this morning talking about the case. So let's see, we're going to squeeze this clip in here. They were out of here after that. Let's see which. Okay, let's go up here. This up. And they were talking about what happened in Monday in court during closing arguments from the defense. Let's shoot this up here.
This yesterday was a long. Justice correspondent Candace Kelly joins us now. Good morning to you, Candace. Yesterday was a long day. And good morning, a triggering day as well. Do we know how long the prosecution's rebuttal will take today?
You know, more than likely about an hour and a half based upon the math that we gave them, as the prosecution had 3 hours for opening and there were 3 closings by the defense here. So she's once again going to take her time and walk us through those facts like she did just yesterday.
Walk us through the defense closing arguments, and let's start with the long, dirty toenails and the impact you think it had. Clearly coded language to a jury of 11 white people, 1 person of color.
Absolutely. Listen, you have somebody talking about toenails at a time where somebody is dead. And the toenails represented that this was someone who could not take care of himself, someone who was not taken care of, someone who might have had some type of a mental illness or disposition, someone who was just wayward and didn't know what they were about. And just this stereotype that Black people just are unclean animals. And that's where this went. And this is why we heard a verbal, wow, I know I heard it, in the middle of this courtroom. And as I was taking notes, I thought, yeah, I wasn't sure. And I said, I was taking notes. I thought to myself, I'm not sure what these toenails had to do with the case or if it was even ever brought up, which is one of the things that attorneys have to follow in terms of those rules. So I couldn't make sense of it till I made sense of it to say this was just really a dig. This was just something that she thought would get the jurors' attention. But listen, Sharon, the way that we are all reacting, and I think that any mother and her child, right? Because this is a mother who clipped that son's toenails when he was a baby. I don't think that it sat well with the jury at all. It was offensive. It was off-putting. And we heard Lee Merritt say yesterday that this is really the time where we call the Georgia State Bar Association. Certainly, Sharon, we had the opportunity and reason to do it way before now. But this was just unacceptable. This was the bottom pit barrel of how you actually go about defending your client.
Yeah, you can't shimmy much lower under the bar that she set yesterday. But let's talk about and dig deeper, because this self-defense argument where Mr. Goff, attorney for William Roddy Bryant, suggested that even an unarmed Black man who is running away is dangerous and you have to protect yourself and even use deadly force against him. Will that resonate? And are there any second guesses this morning about William Roddy Bryant, that he should have been separated from the other 2 at trial?
Sharon, if you remember, a lot during the closing arguments, there were objections to various parts of the closings on both sides because they wanted to make sure that the facts were right and that the law was right. And the judge said, we're going to leave it up to the jurors to remember the facts and law as I give them during jury instructions. If that plays out the way that it is supposed to, if these jurors paid attention to the facts and will follow the law in terms of the jury instructions, there is no way that the defense can come out a winner. There is no way that you can say to yourself, listen, slow down. I need to catch up with you so I can defend myself. That makes absolutely no sense when it comes to the law. In addition to the fact that you have this idea that you have to either be present at the time of said particular felony, or it has to be something that you suspected highly happened. None of this happened in their presence, and so there's no reason why they were to go over to Ahmaud Arbery and follow him in that way. Second part of your question, dealing with this whole idea of severing Roddy from the case, William Roddy Bryant. We heard this more than a half a dozen times. This should be severed. The reason this is important is because if the attorney, Kevin Goff, can convince the jury that he was not a party to this crime, then he has the opportunity to get off on lesser charges in terms of other things that might be considered. This is why we heard the judge talk about reckless driving, because that would apply to Roddy and it would apply to Travis, adding lesser charges. But if he can prove that Roddy Bryant was not a party to the case, then he has the opportunity to either go home or to get out of there with lesser charges. Whether or not that will happen, I don't know, because he was part of the false imprisonment. His car did corner in like a rat, Ahmaud Arbery. I do not see that there is any way that he can get out of that felony, which is one of the underlying felonies, the felony murder in this case, Sharon.
All right, well, it's going to play out today. We'll see how long the jury deliberates in this case. But let's turn to Kyle Rittenhouse, a free man, smiling, leaving prison, and then right into that interview with Tucker Carlson and Fox. Let's play a little bit for you.
This case has nothing to do with race. It never had anything to do with race. It had to do with the right to self-defense.
Right.
I'm not a racist person. I support the BLM movement. I support peacefully demonstrating.
You first, Candace.
I was just about to say, who's first on this, Sharon? Because, listen, this is a young man that knows that he is free, and he knows that the evidence that was not allowed in court gave him the opportunity to say something as preposterous as what he did. And he supports the Black Lives Matter movement, when even while on bail, he was seen taking pictures with white power enthusiasts and people who threw up signs that aligned with white power. This is someone who has been online talking about how he wished that he could have taken out someone. This is someone who thought that this was the protest, that he needed to get his mother to drive across state lines in order to protect a place that he was not asked to protect. Now he's saying that he supports the Black Lives Matter movement. Can he be serious? I think he takes himself seriously. He also looked like someone who had a bright future ahead of him. This is someone who they say might run for office. This is someone who we know has many internship opportunities available to him. This is someone who's going to continue and perhaps finish at Arizona State University. This is what I saw, someone who on the stand was making it up as he went along, and he continued to make it up on that interview with Fox News.
Yeah, it's interesting, Candace, because I saw in the wide shot two men soaked in white privilege. And one of the things about white privilege is it does allow you to rewrite history. It allows you to rewrite history and go on and have enormous opportunity. We'll be following what else? Yeah, it's so comfortable. So comfortable. You're right, Candace. We'll keep following. Well, the Brunswick case is top of mind this morning, and then we will continue to see what else Kyle Rittenhouse says and goes on to do. He's free to do it in America.
Okay. So that was from Start Your Day with Sharon Reed. Candace Kelly does legal analysis on Start Your Day. Candace Kelly and I are sometimes co-panelists on Roland Martin Unfiltered. We were co-panelists on Friday's show, Friday, November 19th. We shared a couple of excerpts here on this show. Very quickly, read this article here, dealing from NBC News, dealing with Kyle Rittenhouse. Now, this was an interview that Kyle Rittenhouse did with Tucker Carlson, white supremacist Tucker Carlson on Fox News. Now, the question I would ask is, okay, so he says he supports Black Lives Matter. He's not a racist. He supports Black Lives Matter. So my question to Kyle Rittenhouse is, one, when did you start supporting Black Lives Matter? And two, what have you done to support Black Lives Matter? Because when you went there to the protests in Kenosha, Wisconsin to protect property, you didn't say you were going there to support Black Lives Matter. So, I mean, that was a protest after Jacob Blake was shot by police officers. So you didn't say you were going there to support Black Lives Matter. You said you were going there to protect property, protect the car dealership. Okay. So he says he's not a racist person and all this. Okay, maybe he's not. He said this to Tucker Carlson. Now he's getting backlash from the white supremacists in on the right wing. He's getting backlash from them for saying he supports Black Lives Matter. We'll see what he says next. He says, I believe there needs to be change. I believe there's a lot of prosecutorial misconduct, not in my case, but in other cases. And it's just amazing to see how much a prosecutor can take advantage of somebody. It's amazing to see how a white judge can help you also. Okay, so Rittenhouse's lawyers argued that Rittenhouse, neighboring, we know I broke down the Wisconsin gun laws on yesterday's show, and Wisconsin self-defense laws that need to be rewritten. The gun laws and self-defense laws need to be rewritten because in Wisconsin, based upon the self-defense laws, even if you were the one that provoked or started a situation, you can still claim self-defense based upon Wisconsin self-defense laws. So he said, conservatives Rittenhouse's acquittal sparked some protests around the country while many conservatives rejoiced. Conservatives paid most of his $2 million bond last year through a legal defense fund, and he has been met with praise by right-wing commentators, including Tucker Carlson. Now, after Kyle Rittenhouse was released on bond, last year, after he was released on bond, prosecutors say he was spotted at a Wisconsin bar flashing the OK white power symbol, the OK sign, a gesture that has been co-opted by known white supremacists. He was also seen consuming alcohol while being serenaded by a group of adult men who sang the Proud Boys anthem, according to prosecutors who filed a motion with the court to restrict him from doing such things. So, let me see which. Okay. Now he is looking at civil lawsuits, and you can read this piece here from this other article here from NBC News. There was also one from rawstory.com. You can read this other one here. Could Kyle Rittenhouse face penalties despite acquittals in Kenosha deaths? The Illinois teen won full acquittals in criminal court, but the possibility of civil lawsuits is still looming. And there was also one from rawstory.com. There was one from, let's see, which one is this? There was one from rawstory.com that dealt with a segment on CNN. This one right here. Like OJ, CNN legal analyst warns that Kyle Rittenhouse is at risk for civil lawsuit from victims' families. So read this one also here. Read this one here from rawstory.com. Like OJ, CNN legal analyst warns that Kyle Rittenhouse is at risk for a civil suit from victims' families. This is from November 21st, 2021. And this is a segment. This was Jeffrey Toobin. Okay, this was Jeffrey Toobin on CNN who dealt with this. And he said he's acquitted of murder as everyone. So just to refresh people's memory with the O.J. Simpson case, Jeffrey Toobin began. He's acquitted of murder, as everyone remembers. And then the family sued and received a very large damage judgment because it's a civil proceeding and has a lower standard of proof. It's a preponderance of evidence in civil court. Jail is not on the table. Prison's not on the table in civil courts, in civil lawsuits. So I think the victims here might well sue Rittenhouse for civil damages. Might sue him for civil damages. Whether they ultimately recover any money and actually be paid that money is a separate question. But I think he is very much at risk for a civil suit from the families of the victims. Okay, so check this out also. They have the video in there from CNN. All right. We have to get out of here. If you'd like to stop information, you can support the African History Network, $, the AHN Show through Cash App. $, the AHN Show through Cash App, also through PayPal. PayPal.me/the EHN Show, PayPal.me/the EHN Show. And at our website, AfricanHistoryNetwork.com, click on the yellow donate button. We're here 6 days a week. This helps us keep doing the research, stay on the air, keep broadcasting, pay some of the bills, etc. And you can register for the online courses that I teach on Saturdays and Sundays. From the Civil War to the Civil Rights Movement and Black Power, 1865 to 1968, and understand the transatlantic slave trade, what they didn't teach you in school. Ancient Kemet, the Moors, and the Ma'afa. Understanding the transatlantic slave trade, what they didn't teach you in school. We do the sessions live, usually Saturdays and Sundays, 12 noon to 2 p.m. Eastern Standard Time. As soon as you, but all the sessions are recorded. You can go back and watch them anytime. So as soon as you register, you can watch the previous classes and watch the class we did last weekend. Okay, from the Civil War to the Civil Rights Movement and Black Power, 1865 to 1968. And then understand the transatlantic slave trade, what they didn't teach you in school. Ancient Kemet, the Moors, and the Ma'afa, where we deal with thousands of years of history, and we deal with what leads up to the transatlantic slave trade taking place. So those are on sale. Regularly $130. Understand the transatlantic slave trade is on sale $60, and from the Civil War to the Civil Rights Movement and Black Power is on sale $50. And even after the 10-week online course is over with, you can still go and watch the entire class. Okay, you'll still have access. You can watch the entire class even like next year. All right, we have to get out of here. Remember, at the African History Network, we focus on educating, empowering, and inspiring people of African descent throughout the diaspora and around the world. Because right now it's correct wrong behavior. It's not over till we win. Wakanda forever. We'll talk to you next time. Peace. We'll be back Sunday. We'll be back live Sunday, 9 p.m. to 11 p.m. Eastern Standard Time. Talk to you later. Peace.
Kwanzaa is coming, and the TheAHNShow.com has all of your Kwanzaa needs. Order your Kwanzaa set today, which includes a kinara, candles, a mat, a cup, the African American flag, and a basket. Visit the TheAHNShow.com, the TheAHNShow.com. They have kinara sets, which include a candle holder, candles, a mat, and a cup. Kwanzaa is December 26th through January the 1st. Add the early bird discount code for 10% off your order placed before November 28th. Visit the TheAHNShow.com and place your order today. The TheAHNShow.com has all of your Kwanzaa needs to celebrate this African American Pan-African holiday. The TheAHNShow.com.
Mental health and well-being have long been a taboo subject in the so-called African American community. So I enlisted the help of mental health experts, thought leaders, and activists to help kill the ghost of Willie Lynch and heal from post-traumatic slave syndrome.
We experience trauma a lot of times on a subconscious level. So sometimes something happens to us and we know that it's traumatizing, but we don't really recognize the extent of the trauma.
Hi, I'm Joel Wilson, President and CEO of JCW Computer Consulting LLC, a technology implementation firm with over 20 years of satisfying customers. We offer a full spectrum of industry top-tier branded services. We are an authorized partner or reseller for Lenovo, Zoom, T-Mobile, Microsoft 365 and Surface tablets, Google Workspace, Acer, Asus, Samsung, PCmatic security software, and many more. Our online store features laptops, Chromebooks, computers, printers, accessories, and software. Businesses, take advantage of our free 1-hour Zoom tech consultation and know we offer top nationwide high-speed internet service providers, voice over IP, and cellular phone services. Home users, don't miss our current in-stock Chromebook inventory. Please visit us at jcwcc.com or call 215-878